The judgment in Osun and the judgment in the presidential, they have a lot of flaws.
Yes, you all, it's Peace TV on today's episode. Practically, we're talking about the Supreme Court judgment in Osun State and the Federation as a whole, connecting with President Tinubu and Peter Obi and Atiku. Now, Akingbolu has actually given his own statements connecting to the Supreme Court judgment, saying a lot and exposing the real truth behind the Supreme Court judgment on the presidential system. Now, looking at the fact that it was looking as if the judges, both from the tribunal to the Supreme Court, was kind of one-sided, Akingbolu explained a lot, trying to make the masses understand the fact about how the judgment is supposed to take place. Now, the Supreme Court saying Atiku cannot present a new evidence is totally not acceptable. Akingbolu explained more connecting to that. Now, please tap on that subscription button, like our videos. As you watch the video next, watch Akingbolu explain more connecting to the Supreme Court judgment on the presidential issue on ground. Thanks for watching.
For instance, if those judgments remain the law, it will be difficult for any petitioner to succeed on any election petition, except we say we should not file election petitions again. Because in Osun, for instance, the judgment was given that, before you can prove overvoting or non-accreditation, you must bring the BVAS report, you must bring a BVAS machine. How can you tender BVAS machine before the court for examination of the court? And that the report of the BVAS must be tendered as well as the manual register. Now, if this were to be case to go by the presidential election, for instance, they have done the states and the state governorship elections, the houses of assembly election, then later before the presidential. And immediately after those elections, the BVAS machine were reconfigured. So there was no how anybody fighting governorship election would be able to get the BVAS report or the accurate BVAS report or the BVAS machine, because the information that will be available now will be the one for the presidential, which is it is not the presidential came first. So if you have reconfigured for the governorship, all those people going for the presidential election petition are not joking, because you cannot get the BVAS. If the Supreme Court has said the only way you can prove those overvoting is by getting those BVAS machine tendered in court and the report. So these are the things. And again, when you are saying they cannot subpoena a witness, it makes it difficult for petitioners. For instance, we all know that INEC will conduct the election, make all their mistakes and all that, but because they know it will be difficult for you to prove it, they can just go scot-free like they have been going scot-free. And now, if they have done that, you are now saying, if you are preparing the petition, how do you get an INEC official or the returning officer to come and make statement on oath for you? So, and the Supreme Court is saying, the tribunal, Court of Appeal said it, the Supreme Court affirmed it, that you cannot do subpoena. You can't subpoena a witness. That will make it difficult for any petitioner to succeed in any election, because at the end of the day, if you ask INEC to come and do witness statement on oath, they will not sign it. This is the truth. So you must still use your normal witnesses. And the law is that INEC documents were prepared by INEC officials. So if they are prepared by INEC officials, only INEC officials can give evidence. But now our court is saying that you cannot subpoena them. And you are calling an adversary. How does it? You can only do that by subpoena, which is a court order.
So let's press it for, because in all of this electoral season case, let's talk about properly understanding the Evidence Act, because that's a big problem.
It is a big problem.
The Evidence
Act, the Evidence Act said if a fact is to be proved, if it is a fact that must be seen, it must be the direct evidence of somebody who saw it himself. If it is a fact that must be heard, it must be the evidence of somebody who heard it by himself. If it is the evidence of something that should be felt, it must be the person who felt it that will say it. If you say somebody, no hearsay. If you say Mr. A told me that Mr. C killed Mr. Z, you understand, and you are telling the court will not believe you. But if you say I saw Mr. A killing Mr. Z, that is the direct evidence. Now, if the courts have been saying that you have to bring witnesses from the polling units to come and give evidence before you can prove anomalies in the polling units, then there's what we call best evidence rule too, which means the documents speak for itself. But our law, under the Evidence Act, it allows that. The document is the best evidence or are the best evidence. But unfortunately, the courts over time have been saying that if you tender the document, the court will not be able to look at it, because looking at it will mean that the court is doing cluster justice in the comfort of their chambers. But I think it should be so, because you have 21 days to file election petition. It used to be 30 days. In 1983, Chief Obafemi did not file election petition, not because he was satisfied with the election, but he said the 30 days limited to file election petition was not enough for me to prepare an iron cast case. So if it was 30 days and it was short, then it's now 21 days. And you go to the tribunal, they say you should streamline your witnesses. In PDP, they have 27 witnesses. I think Labour Party has 13 witnesses. How do you prove election malfeasances, with few witnesses, when we have over 176,000 polling units across the country? And in the case of Buhari and Obasanjo, Patachoronu Obese memory said, to prove for a petitioner to succeed in the presidential election is a Herculean task, and that the petitioner must tender not less than 2,500 witnesses. So where are we today?